Right, okay. Well, thank you all for joining me this afternoon. My name is Fay Collinson, and I'm a barrister at King's Chambers, based in Manchester. We're doing this by a webinar today, rather than the normal forum or format of the sort of Zoom meeting, which I always find quite strange because I can't see any of you. So I normally rely on seeing everybody's faces to see whether what I'm saying is resonating with people. So I hope that it will today. But the reason we've had to do this by way of a webinar rather than a meeting is because of the sheer number of people that wanted to join today, which I was quite surprised at, because there was such a big difference between the numbers today and the numbers we usually have for our seminars. And that then got me thinking that there must be a reason for that. Now, it may just be because you all really enjoy my seminars, or it may well be more because of the particular topic that I've gone with today. And so I did a sort of quick Google search to see what information there is there about the capacity test for lasting power of attorney. And I had to say, there wasn't a great deal of information. Now, if you Google testamentary capacity, Banks and Goodfellow, there'll be lots of articles that come up with this is the test and this is the kind of stuff that you need to speak about or establish with a testator or a testatrix. But there's a real difference with LPAs. And so maybe the reason why there's such an appetite for today's seminar is perhaps because of that paucity of information. So I hope, or certainly it's my intention to try and fill some of that as best as I can. Now, today is called LPAs, Capacity and How to Get It Right. And really the focus of today is to really go through as best as I can, and without trying to be boring, because I know law can sometimes be quite boring, the test of capacity within the context of a lasting power of attorney. Now, I'm going to be focusing on, as I very often do, about property and affairs, LPAs, because my practice is very firmly based within the property and affairs side of the Court of Protection. We're down for now. I'm not going to take that much of your time. And I'd hope that I could deal with in more detail with the contentious side of the applications, but I've had to cut it short just because of some of my other professional obligations I've got this afternoon. But I will certainly deal with that on another day in more detail. But at the end of the seminar, I hope to go through that in just some detail for you. Now, before we get going, let me just try and work these slides. That is the Just Giving page of one of our lovely receptionists, Kim. And just before I started this webinar, I had an email from our Chambers director, Debbie, and she said, Kim, who is a fabulous singer, and you may want to give her a Google on YouTube, because she was on The Voice a few years ago. She's currently raising money for, I think it is I can't remember the name of the charity, but it certainly has something to do with dementia. And so Kim is going to care homes and singing from the outside of the care home through the window to those individuals who are at the care home, who, of course, like many of us, are separated from our loved ones. And so she's doing that to raise money. And so I thought, given the topic of today, given it's also such a great cause that many of you will support separately, that I would give those two links. The top is just the Just Giving link, and also the second one is just a sort of article that Isle of Manchester did on Kim. So if you do have some pennies to spare for a good cause, then please do visit. Now, just for those of you, that picture makes me laugh. It's my dogs, and I've put some wigs on them because I just thought it was so funny. But for those of you who are new to King's, welcome. We're all very, very friendly. We have a specialist wills, trust and probate team and a specialist Court of Protection here at King's. I specialise in probate work, trust work, Court of Protection work on the property and affairs side, and property work. And that is some of the things that people, i.e. the Legal 500 and Chambers of Partners, have to say about me, I always say, and I do always mean this, that I am always happy to have informal discussions with people about matters. And I do have, as best as I am able to, an open virtual door. So there is my email. If you have any questions about today or about any other matters that you want to run past me, then I think we do have a chat function on here that you can use. I think it's this Q&A function up here. Or by all means, ping me an email and I'll do my best to respond to that. Now, moving on to what we're actually here to talk about, and it's about capacity to execute a lasting power of attorney. Now, I put a LinkedIn post about a case that I was involved in recently, which was really the sort of inspiration for this topic. And in my own practice, I've seen a growing number of challenges to lasting power of attorneys. And so I wanted to just posit with you this scenario that is one that has cropped up in my own practice. So a gentleman goes to see a solicitor. He is an elderly gentleman and he is in his 80s. And as many people wish to do, he wants to make a will and lasting power of attorneys in respect of his health and welfare and also his property and affairs. Now, he goes to the solicitor on 2 occasions. He goes in the April and then he goes later in the June. And it is on the 2nd occasion that the documents are executed. Now, when he goes to the solicitor on both occasions, his son accompanies him, which in itself is not improper and is quite common. At the actual attendance, the son isn't with the gentleman, the son is sat outside. Now, the solicitor who assisted this gentleman with these documents was a very experienced solicitor. It was a solicitor who was a full member of STEP and also other organisations such as Solicitors for the Elderly, which many of you may well be members of. And this individual was a specialist private client non-contentious solicitor, so had a huge amount of experience in not only drafting wills, but also lasting power of attorneys. And this particular solicitor took the view, having met this gentleman on 2 occasions, that he was lucid. And the term that I often see I often see that he also knew his own mind, i.e. he knew what he wanted to do about his affairs and about his dispositions post-death. At the time, what the solicitor was unaware of, and this is the sort of nightmare scenario for non-contentious solicitors, is that the client was actually suffering from short-term memory loss, and certainly I want to say minor short-term memory loss, and episodes of confusion. There was also, as I frequently see, some family divide in that the siblings disliked each other, and there were other disputes about what care needs their father had and where he should live. Around 3 or 4 weeks after the LPAs were executed, the gentleman moved to a care home and very sadly then suffered an acute depressive episode. What then happens? Around about 6 to 12 months afterwards, there was a challenge to those LPAs, and ultimately both health and welfare and the property and affairs LPAs were revoked. And that perhaps is one of the nightmare scenarios for an experienced solicitor, whereby you make an assessment of somebody's capacity at the time, and then there is a challenge taken to the LPAs shortly after. Now, what the solicitor had taken the view on the whole situation was that she considered that during the attendances, it wasn't her place or her role necessarily to interrogate the gentleman on what his assets were, what his background, what the family dynamics were, and that it was considered to be verging on a little bit rude to effectively cross-examine your own client. And that is something that is often said: where do you draw that line between making the inquiry that you need to, but not at the same time coming across as though you're cross-examining and being hostile towards your own client. And the solicitor also took the view that carrying out a formulaic, formal assessment of this gentleman's capacity might be interpreted by him as being a little bit patronising and quite intrusive, because, as we all know, just because somebody is elderly does not mean that they lack capacity, or that we should discriminate against them on that basis. And what this solicitor did, and I hear this all the time, is that they relied on their own experience and their tone and content of the discussion with the client to come to a view that at the time he retained the capacity to execute both LPAs. There was, however, or there were problems with that approach, and it is that has sort of led me to outline how an approach with hindsight might be slightly different. There was no attempt, it seems, by the solicitor to carry out what you call a functional capacity assessment. The solicitor had relied upon her own sort of general overview of the conversation, and that just kind of feeling of, does this person have capacity, which is what a lot of solicitors in practice do. Now, I'm going to come into a moment what a functional capacity assessment is. Criticism that was also levied was that this solicitor didn't follow the golden rule. Now, the golden rule is really directed towards the preparation and execution of a will, but in this instance, whilst there was a will being executed at the same time, the golden rule wasn't followed. Also, this was a new client, and it was felt that, given that it was an elderly client and also a new client, that there was a responsibility to go that much further in establishing capacity and looking into the background. And also the other point that was made, that given that there was non-compliance with the golden rule, and so evidence of a GP or another suitably qualified practitioner wasn't obtained, that there should be a functional capacity assessment carried out by the solicitor, but then, having done so, that the results of that functional capacity assessment should be properly recorded in the attendance notes on both visits, and that the solicitor didn't substantiate or explain their assessment of the client's capacity in the attendance notes. So it was the case that, rather than saying, I did X, Y, and Z, it was simply a conclusion that I'm satisfied this individual retains capacity to execute these documents, without actually documenting, detailing, and explaining the analysis that had led the solicitor to come to that view. So that is, as I say, fairly nightmare scenario for solicitors, and it's a scenario that you will wish to avoid because for a lot of reasons, certainly a potential negligence claim, but also I raised this point, which is that very often when you have an LPA that is executed at the same time as a will, if there is a successful challenge to a lasting power of attorney during the course of P's lifetime, then that can have potentially implications for the will. Because if you have a finding during P's lifetime that on balance this person lacked the capacity to execute the LPA, then when you come to a post-death will challenge that was executed on the same day, you've already by that stage got a finding on balance about capacity on one matter that is most likely to be relevant to the other matter of the will. So it can have problems for the validity of the will that's executed at the same time. Now, I'm just being told here that people are raising their hands, but I have no idea, I'm afraid, how to deal with that. So Jill, if you've got a question, I'll try and deal with that later. So just a couple of points that I want to make about capacity. Now, one of the things you need to think about is I'm having other people raising their hands, but I have absolutely no idea how I deal with that. I hope you can all hear me and it's not an issue. I've only got one person raising their hand, so hopefully it's not an issue. But anyway, so the first thing to consider is the material time. When are we actually assessing capacity? Now, as I say, in that scenario, a solicitor had met the client on one occasion in the April and then a second occasion in the July. Now, the Mental Capacity Act says that in order for an LPA to be valid, the donor has to have capacity at the point of execution. So that is when the donor effectively puts pen to paper and when they sign their name on the relevant section of the form. And so that means that if you have an assessment at a first attendance, you then need to repeat that at the second attendance if that is when the individual is going to be signing the LPA. Sometimes what occurs is there is a first attendance where all the information is given, the explanations are given to the client, and then they go away and take with them the various forms and the various leaflets, have time to think about it, and then they come back at a later date to actually sign all the various documents. Now, if that is happening, if you do have a donor who falls into that category of client where you do need to take those extra steps and your assessment needs to be perhaps more comprehensive, then you do need to repeat your assessment at the second attendance and not just rely on the first one. Because if there is a later challenge and you can show that you did X, Y, and Z in the April, but you then didn't do that at the time of signing, then the weight that can be placed on your contemporaneous assessment is going to be much less and potentially none. Now, the second point is the presumption of capacity. And we all know what it is, and I raise it for a couple of reasons. The first is just to highlight the significance of it within the context of a challenge to an LPA. I found this phrase used by Mr. Justice Hayden in the recent case of London Borough of Tower Hamlets and PUB, because I thought it was quite useful actually to emphasise the significance of the presumption of capacity, because here he says that it's every bit as important as the presumption of innocence in a criminal trial. And we all know how important the presumption of innocence is there, and that you have to be sure. Of course, we're dealing with a different standard of proof, so remember that. But here it can only be displaced by cogent and well-reasoned analysis. So the standard of the evidence that will be required to challenge that presumption has to be cogent and it has to be well-reasoned. And the other reason I raise the presumption is just to highlight the difference between a challenge to an LPA, which is going to be during P's or the donor's lifetime, and then the challenge that may be made to a will, because they are slightly different. And the consequence of it, as far as I'm concerned, is that a challenge to an LPA should be harder and it should be more challenging than potentially a challenge to the will post-death. And I say that for this reason. When we are looking to challenge a will, for instance, on the basis of somebody lacking testamentary capacity, there is an evidential presumption of capacity. But the person who wants to pronounce against the will may say, well, there's a real doubt about capacity. And raising a real doubt is actually relatively easy if someone is infirm, if someone is elderly, if someone is just suffering from dementia around that material time. That in itself can raise a doubt. And if the individual who wants to challenge the will does raise that doubt, then there is the requirement for the person who wants to prove the will to actually prove testamentary capacity. So most post-death will challenges are dealt with on that basis, where there is actually the requirement to prove capacity. Here, however, with lasting power of attorneys, it's different, because we've got the presumption of capacity, and it can only be displaced if there is evidence to show that the individual at the material time lacked the capacity to execute the LPA. So really, the consequence of that should be that it is harder to mount a challenge to the LPA than it is to a will. But sometimes in practice, that can get a little lost. Now, here's where we're getting to the stuff that you need to be focusing on when you're dealing with non-contentious drafting of LPAs. The test, as you know, is set out in the Mental Capacity Act. And it's, despite all the wealth of authorities, it has been condensed essentially to this. There is the two-stage test, and it's separated into the diagnostic test and also the functional test. The diagnostic test, as lawyers will be saying, I cannot deal with that aspect of it because I am not a medical practitioner, and I, of course, can't diagnose dementia or any other mental impairment. And of course, you would be right about that. But the functional aspect of the test is, in my view, something that, providing you have the appropriate experience and training and can ask the right questions, you can carry out that assessment. And so it requires, dealing with that two-stage test requires asking these three questions. And so this is the sequence in which you need to be thinking about it. The first is the individual unable to make the relevant decision? So here is the donor unable to make the decision to execute the lasting power of attorney. Then you have to ask, do they suffer from an impairment of the mind? And thirdly, are they unable to make that decision because of that impairment of the mind? Now, as I say, the functional capacity aspect is encapsulated in the first question that we have there. And so there has to be express consideration about whether somebody's unable to make that relevant decision. And that requires considering whether they are unable to retain the relevant information, communicate the relevant information, understand the relevant information, and weigh up and sift through the relevant information. And if the donor is unable to do any one of those things, then they are unable to make that decision. Now, you can, as part of your assessment of the client, come to a view on that, or certainly come to a view such that you think, right, this person does really need to have some medical evidence before I can make that call on whether to go ahead with this. And so what you really need to know about is what the relevant information is. And that, I think, is when I did my Google search earlier, that's where there really wasn't any information that I could find readily on the types of things that you need to be considering when you discuss with your client what the relevant information is. And so this relevant information, which I'm going to go into in a moment, the donor has to have the ability to understand it. And I emphasize the ability because someone may not understand it because they don't have the knowledge of it. And a lot of people, whether they're elderly or young or educated or not, will not have a great deal of understanding or knowledge of an actual lasting power of attorney, because they are actually quite a sophisticated document. So there does need to be, I think, with most clients, some education on not just what they are, because most people in broad terms know what they are, but what powers it confers on an attorney, What they can do, what they can't do. If something goes wrong, what can the donor do about that? If they've lost capacity by that time, what can they do about that? So there's actually a number of things that need to be actively thought about by the donor in order to make that informed decision. Now, here are the basics. So when you're with your client and you come to the view, and I pause there to say, you don't have to do this with every client, because of course you may have someone like me who, generally speaking, I would hope most people wouldn't have a doubt about my capacity to execute an LPA. Or I suppose it depends whether they catch me on a Friday night or whether it's midweek. But I would hope that most people wouldn't have a doubt about it. And so the extent to which you need to go through and assure yourself of understanding obviously depends on the client. And what I'm really focusing in on here are those clients where you can foresee a challenge at a later date. And that is going to be individuals who are elderly, or ones where you are perhaps put on notice that there is some background family animosity. Because sometimes LPAs are created without other family members knowing. And then that suspicion can give rise and motivate other family members to challenge them. So the very basics, and this is what's actually on the OPG website, are these 5 considerations. And so an individual obviously needs to know obviously need to understand what an LPA is. Now, most people will be able to say, it will allow my daughter to look after all my money for me. And it may well be they just need a bit of an explanation about, well, actually it goes beyond that. And it's up to you as the individual drafting or executing this LPA form to provide this information to them, whether they are a sophisticated client, an unsophisticated client, an elder client, or a young client. It's part of your duty to appraise them of the document that they are looking to embark upon. They also need to understand why they want to make an LPA, so what they hope to achieve by it. They also need to understand and be able to explain who they want to appoint as the attorney, and why does the donor want to appoint that particular person. And they need to be thinking about, well, what are the consequences if I appoint that person, and why am I not appointing that person instead? So balancing the consequences of doing it, not doing it, appointing the son but not the daughter, or appointing them jointly and separately. And then finally, they have to be able to understand what powers the lasting power of attorney will give to the attorney. Now, that is a very basic approach, and it is an approach that in most cases will suffice. But when we are actually looking at a challenge within the context of litigation, the test for capacity is more sophisticated and more complex than that. And that is what I propose to deal with in a bit more detail. So beyond those 5 things in the previous slide, what we need to be looking at and addressing with the client are these matters. So they need to be able to understand that the LPA must be registered before it can be used. So they need to be able to understand that once they've signed it, that's not the end of it, that further steps need to be taken until it's actually an operative document. They also need to understand that the attorney is going to have complete authority over the over the donor's affairs. That's of course going to be subject to any conditions or restrictions that the donor places. So of course, that understanding of the authority will change depending on the nature of the instrument. And that's why I say this sort of simple approach of they're looking after all my money is perhaps not going far enough, because they also need to understand that with the lasting power of attorney, that the attorney is going to be able to do anything with the donor's property and affairs that they could have done themselves. So they need to understand that potentially the house could be sold and a new house bought for them, that then their money can be used to fund care home fees, that they then may be able to invest things, that they may be able to exercise very limited trustee powers, that there are limited powers to make gifts and on what occasions. So it's not just that simplistic approach of looking after the money. There are layers to that individuals need to understand. And they also need to understand that the lasting power of attorney can be used when the donor lacks capacity, and when, of course, subject to any restrictions or conditions that can be used when they retain capacity, but of course with their authority. They also need to understand that the donor can revoke the lasting power of attorney at any point whilst they retain capacity. So the donor needs to understand, and this leads into the next point, which is of the reasonably foreseeable consequences of executing the LPA or not executing the LPA. And it's going to be an understanding about, well, if the attorney does something wrong, what can I do about that? If I change my mind and I fall out with my attorney, what can I do about that? And it may well be that that's obvious, but when you have an individual who you may have concerns about their level of understanding, it will require consideration of matters such as that. And here is the final, but I think one of the most important things that is, in my experience, most often missed, is that there needs to be this understanding by the donor that when the authority is exercised by the attorney, when the donor lacks capacity, that is subject to the Mental Capacity Act 2005, and that it has to be, the authority has to be exercised in the individual's best interest. So that is a summary of the authorities on capacity to execute an LPA. By all means, take that summary and use it, although of course go and sound check it yourself. But by all means, you can use that as a framework for when you are considering the issue of capacity, to check that you are considering all the matters that you need to. Now, it leads to the question of, well, when you're assessing somebody's capacity, why is expressly considering all of those factors so important? As I say, there'll be some cases where you won't need to go to that level because it will be so obvious, and it is highly unlikely that a doubt about capacity will be raised. But where we are have clients where the risks of a challenge may well be greater, then in my view, it is prudent and wise to be setting out expressly that you have considered those factors to which I've referred, and how you have tested the donor's understanding of those matters. But I say it's important in the context of a later challenge to an LPA, because the reality is, if an application is brought under section 22 of the 2005 Act, and that's the section that gives the authority to make a declaration on the validity of an LPA, it's really going to fall down to 2, possibly 3 key types of evidence. And in my experience, it's usually a straight fight between the solicitor's contemporaneous evidence and the special visitor report that the OPG will undoubtedly obtain. And so you have this classic contest between contemporaneous evidence and a contemporaneous assessment of capacity. Now, pausing there, that's important because, of course, we know capacity is time and decision specific, versus a retrospective capacity assessment. Because what will often happen is the special visitor will go and see the donor, who by this point has lost capacity on the relevant issues, and they will carry out an assessment of whether they have capacity to currently revoke it or make a new one and manage their affairs. And then they will look back through the medical notes and make an assessment, essentially by way of a desktop report on the issue of capacity. Now, there are authorities, both within the probate world and within the court of protection jurisdiction, which make plain that a retrospective capacity assessment can only be taken so far and can only have so much weight. And it will almost always be the case that as long as a court can place confidence in the solicitor's assessment of capacity at the material time, then that will be preferred to the retrospective assessment of a special visitor. And then it flows to this issue, which is, well, what weight can the court place on the solicitor's contemporaneous assessment? And that is why the quality of your assessment, the extent of the assessment, and the recording of that assessment is so important, because you may well have done it, but it's simply not there in evidence. And if it isn't, it can be fatal to seeking to uphold the impugned LPA. So taking all of those matters into account, taking into account my own contentious litigation experience of these types of applications, I've come up with a number of points that I think should be borne in mind. The attendance note will inform what you put in your witness statement. What will likely happen is, if there is a challenge to the LPA, the OPG will contact the solicitor who dealt with the LPA, and they will ask a number of what I have come to believe are probably stock questions, because they appear to me in each case to be the same question. And they will ask, it's kind of like a Larkin-Nugas approach, really, and they will ask what and how you assessed the individual's capacity at the time. And your answers will, to some extent, determine whether that application needs to be brought to court. And so this may be 6 months after the LPA, it may be 5 years after the LPA. And as with all witnesses, professional or lay, recollections will fade. And so you will have to look back to your contemporaneous notes in order to put forward a witness statement. And you will be expected to provide a witness statement in the litigation in the same way that you have a professional duty to assist the court in a probate action. So that leads me on to this second point, which is detail. My experience is that the LPAs that are more liable to challenge are the ones where the attendance notes just don't go into the level of detail that they perhaps need to, or with hindsight should have done. It doesn't mean that the solicitor didn't do it, but of course it's being dealt with on the balance of probabilities and looking back at the evidence. And so the court has to deal with the evidence as best as it can. And what can sometimes undermine evidence by any witness is if they start introducing details that aren't in the earlier contemporaneous document. So if you start giving evidence and saying, well, I remember X, Y, and Z, but it's not in your attendance note, it is likely to be used as a basis to suggest you might be innocently reconstructing matters. And I also raised there about, I like to call them little nuggets, because, and this applies whether we're dealing with wills or LPAs, there are some things that clients will just say to you that just resonate as being quite credible, and very often I see those put into attendance notes, and it gives everybody a sort of flavour of the attendance. Now, sometimes it can be because the person was actually delusional, and so sometimes they say things that then other family members will say, well, that definitely wasn't right. Other times it can show the level of rapport that the solicitor has, and it can show to individuals that the individual was functioning well and wasn't impaired. So if there are any little aspects that a client shares with you during your attendance that fortify your view that they retain capacity, then I always think it's better to put those in your note than not. And it's sad to say, but this is the way it is, that there has to some extent be a bit of a defensive practice with these things. But that is sadly, in a litigious world that we're in, the way things are going. Now, and I think the third point is probably the most, if you can take one point from this, I think take this, it is, I think, express reference to the relevant information within your attendance note can really dictate the way that a case goes. I see it quite commonly in probate actions where a solicitor will say, this is the Banks and Goodfellow test, and I address this with the client by covering these topics and asking these questions, and this is what the person said to me. And so drawing all that together, I've taken the view that they have testamentary capacity. I don't often see that actually with LPAs. It may well be because by the time they get to me, those ones that do that have been filtered out and the OPG hasn't continued with the application, so it may well be. But I think that if you have an individual where it is more likely that the LPA might be challenged, that it's certainly wise and prudent to set down the relevant information in the other slides, and then also set down how you tested that. Now, test is a strong word because it's not sort of asking your client a question and they have to pass it, but certainly you can't, I think, with some individuals, accept things unquestionably. And I think that's where it can cause an issue, because individuals with dementia can confabulate. The social facade, which I refer to slightly further down, is well known. It's often the case that individuals, especially elderly individuals, when they go to see a solicitor, they see it as an event, they will dress up, and they can prepare with stock answers to the questions that they might anticipate in order to hide the fact that they are suffering from an impairment or some memory loss. And so sometimes that can lead individuals to accept what is at face value a superficial level of understanding. And it's about, I think, teasing out any concern about their understanding by just with appropriate questioning, and I'm not saying cross-examination, but asking them questions, posing scenarios, things like that. And that's a way that you can test whether somebody is understanding the matters that they need to. And if you can demonstrate at a later date to a court that that's what you did, that's how you did it, and therefore as a result of that you came to the view that that individual retained capacity to execute the LPA, then you are going to put it's going to be much harder to, I think, challenge that type of assessment with a retrospective capacity assessment from one of the special visitors. Also think about whether there's a need to do it over a couple of attendances. I know that cost can be an issue for clients and that these things are sometimes dealt with on fixed fees. So I recognise there's a bit of an internal conflict there. But sometimes, you know, for example, I have clients who might have learning disabilities, and it's a question of meeting with them more than once to gain their confidence and to understand how best to communicate with them. Because sometimes people do understand, it's just that the way it's being explained to them might not enable them to understand. And so sometimes there has to be more than one meeting in order to best enable an individual to retain capacity at that time. And then if there is more than one attendance, well, what steps should you take at each one? And it alludes back to the point that I made earlier, which is that if you do your assessment on the first attendance and there is a gap to the second one, you really must be able to show, if it is later challenged, that you repeated those steps and reassured yourself of capacity at the second occasion. And I do often see that is a downfall, that the steps are taken at the first one, and then there's just reliance placed on that, but things can change within a few months. I also think it's important to be mindful of the presence and involvement of family members. My perspective is probably to some extent tainted by the fact that I am a litigation barrister. And so I always see the bad side, and I see it by the time it's got to me, it's hostile, it's emotionally driven. And I see a lot of undue influence and a lot of financial misappropriation. So I'm mindful that I see that. But the converse of that is some people who are in non-contentious practice areas don't see that. And so sometimes you can have family members who do appear as though they are just doing the right thing, helping mum or dad to get their affairs in order, when actually there might be an ulterior motive. They might be doing it in secret so that nobody else knows. They might be doing it at a particular time of the day because they know that mum presents better then, but actually on other times in the day she can be very impaired, but then doesn't tell the solicitor about that. And so it's important, I think, to, as best as you can, explore with an elderly donor what is the family position? Do they know about this? Why are you only appointing one sibling and not the other? New clients as well. As I said earlier, one of the criticisms was that where the elderly gentleman was a new client, that there was an obligation and a responsibility to carry out that functional capacity assessment, because it may well be that he was presenting with that social facade and it was superficially quite convincing, and had the functional capacity assessment, which went that much further, been carried out, then it may have identified at that stage that there were concerns or doubts over capacity. And then, of course, once you've carried out that functional assessment, then it will help you better determine the issue about medical evidence. Now, with LPAs, it's less common that there is, I think, I say this with some caution, but it's less common that there is a rush to have the LPA executed than with the will, though I appreciate sometimes there are times when there does need to be. But as with any will, I would tread cautiously without obtaining some medical evidence. I personally don't think GPs are particularly well placed to give that report because they don't have the time, and their understanding of capacity in this context is perhaps not across the spectrum as good as it might be. But whoever you are asking to assist you with this, make sure they know what the relevant information is, because that, I find in my experience, is where the knowledge is perhaps not as good. And as long as they have that, then they know what issues need to be addressed with that donor. And then just finally, if very briefly about contested applications, and I plan to deal with this in more detail on another day, but they're usually brought there by the OPG. They don't have to be. They are often bought by local authorities if there is concern, particularly about capacity, financial misappropriation, things of that nature, or family members as well. Thing to be mindful of, and this can cause practical problems, is very often when the case is down in London before it's moved up to the local hub, if there is prima facie evidence for certainly the court to make an interim declaration, there is a good chance that the LPA may be suspended in the interim. And that causes problems for the family, because then the family find themselves in a position where they don't have access to funds and so can't pay care home fees, for instance. And so the family are then put upon to pay those in the interim. So be alive to that. And if that does happen, unless there's any impropriety or alleged impropriety about the attorney's conduct, then be thinking about making an interim deputy application so that P's financial needs are met in the interim. There will often, as I say, be from the OPG a special visitor report. More often than not, they're from a psychologist, and they have a list of individuals that they use. If you're on the side that wants to challenge the OPG's application, certainly think, notwithstanding the presumption of capacity, I would certainly encourage you to think about getting your own report. And more often than not, the court will be amenable to it, at the very least, a joint instruction. But in many cases, I get my own report. And look at experts who are more qualified than the OPG's special visitor. I tend to use the ones that I use in my probate claims. I'm a really big fan of Professor Alistair Burns. He's done some great reports in my cases recently. Hugh Series is also a decent expert as well, and I'm sure many of you will have your own too. But think about those pieces of evidence at an early stage. And what will happen is, once the application's been issued, the London hub will send out sort of general directions for it to be served on the respondents, and that's when you have your first opportunity to set out what your evidence is. And then it will be listed for a dispute resolution hearing. And there is very often, I think, some encouragement from the judiciary for parties to settle at these DRHs, and I understand that, because the default position in P&A cases is that P pays for the costs of it, although the OPG don't ordinarily seek their costs of it. And so I see the benefit, absolutely, in settling. And sometimes it may well be that even if the LPA is valid, that there are other reasons why it just can't work in practice. You've got huge hostility, which means it makes it invidious for the current attorney to carry out that role, because the other family members just make it so difficult. And there is some injustice in that, I think, because it's not what P's wishes and feelings would be. But the reality is there is in any case a conflict between preserving P's estate, so it's spent not on lawyers but on meeting their needs. And I've dealt with further medical evidence. One of the things you will need to think about if you are a party opposing the OPG's case is you need to get the file from the solicitor who dealt with the LPA. Now, if your LPA has been suspended, you're going to have difficulties with getting it because of, obviously, confidentiality. So you need to be, as early as possible, raising that you need an order for the file to be released. Because without that, you might have certain challenges going forwards in the case. Witnesses, there's going to be a combination usually of lay witnesses, but as I say, as a solicitor dealing with the non-contentious side, then you'll be expected to be involved and assist the court. There is also the matter of settlement. Mediations can be a very useful tool in this. And then finally, costs. The default position on costs in P&A cases is that P pays the party's costs. There is some injustice in that, I think, but the court has the discretion to depart from that, and it does do that. If there has been some form of unreasonable conduct, but really it's the scenario or the outcome that meets the justice of the case. And so, as there is in the civil jurisdiction, there's a broad discretion, I suppose, to make whatever cost order it needs to reflect the circumstances. And one thing to be mindful of, I think, if you are for an attorney, is very often lay attorneys will have this sense of, well, I need to uphold mum or dad's wishes. And that's absolutely understandable that they would say that. But it may be that as the case progresses and you review the evidence and you think, well, actually, we might have some difficulties here, and the OPG's report is really quite convincing. It's important to be making your clients aware that it is not uncommon for the COP to say, well, I'll give you your costs up to that date, but once you had that report, you should have taken stock, reflected on prospects, and so from service of the report to the trial, I won't let you recover your costs from P's estate. And so that can have big implications for your client, because if they are anticipating their costs being paid from P's estate and service of the report is quite early on, then they can be left with a relatively large bill. So certainly things to be mindful of there. And so there we have it. I hope that that's been useful. And as I say, if anybody has any questions, anybody has any questions on capacity to execute LPAs or any other matters that fall within the domains that I've spoken about, then please do feel free to contact me at fcollinson@kingschambers.com. I'm going to pause it now, and then what I'm going to do is have a look at these questions that people have asked, because it's difficult to do that and present at the same time, and I will endeavour to get back in touch with people. But if I don't have your email address, then by all means email me with your question and I can assist there. So thank you very much for joining me, and I hope you all have a pleasant evening.